Chapter 4 will be talking about extinguishment of obligation. So, how can obligation be extinguished? How does it come to an end? Article 1231 enumerates the different mode of extinguishment of obligation. There are several modes of extinguishment of obligation, which we will learn when we discuss the general provision of Chapter 4. So in Chapter 4, remember, it enumerated as general provision. It enumerated the cause of extinguishment of obligation. So there are actually several. Please take note of the Palo-Remicon. PA will refers to payment or performance. LO will refers to loss of the paid to. RA will refers to remission or condition of the debt, sometimes also known as waiver. MA will refers to merger of the right of creditor and debtor, while CO refers to compensation, and N refers to innovation. There are there are other causes of extinguishment of obligation, such as annulment, rescission, fulfillment of resolutory of condition, and prescription, are governed elsewhere in this Code 1156. Anyways, you can also add to that the other causes of extinguishment of obligation. First, death of party in case of obligation is personal. Because it is personal, obligation is risky, so it can no longer be performed by somebody else, so it extinguishes the obligation. Second, mutual desistance or withdrawal of parties. Parties agreed to mutual withdrawal from the contract. Third, arrival of resolutory period. So resolutory period is an obligation subject to an resolutory period is immediately demandable, but once resolutory period arrives, the obligation is terminated. So once again, it is a cause of extinguishment because the obligation is already existing upon agreement. So they agreed today, the obligation starts today. But remember, the obligation is extinguished or the obligation is terminated upon the arrival of the resolutory period. Fourth is compromise agreement, meaning the parties to settle their contract is usually continuous with the claim when they have demand with each other. They agreed to settle amicably. Of course, if there is amicable settlement or compromise, the obligation is extinguished. Fifth is the impossibility of fulfillment. It is impossible to fulfill. Usually, this will refers to personal obligation that will impossible to do already. Lastly, happening of fortuitous event. This is general rule absent any ground for liability such as mora, violation, culpa, and dolo will extinguish the obligation. Anyway, those are the causes of extinguishment of obligation.
Section 1. Payment or performance. Under the article of 1232, payment means not only the delivery of money, but also the performance in any matter of an obligation. For example, X owns Y 5,000. Also, X bound himself to repair the bicycle of Z. If X paid his obligation of 5K to Y, then there is a payment. Likewise, if X repaired the bicycle of Z, then there is a performance. As a rule, one who pleads payment has been the burden of proving it, even where the plaintiff must allege non-payment. The general rule is that the burden rests on the defendant to prove payment, rather than on the plaintiff to prove non-payment. The debtor has the burden of showing with legal certainty that the obligation has been discharged by payment. A plus post is the rule so well settled that a receipt or payment is the best evidence of the fact of payment. A receipt is a written and signed acknowledgement that money has or goods have been delivered, while a voucher is a documentary record of a business transaction. It should be noted that a voucher is not necessarily an evidence of payment. It is merely a way or method of recording or keeping track of your payments made. It must be supported by an actual payment of cash duly received for a customary among businessmen or the issuance of a check subsequently encashed. The law provides that the delivery of mercantile documents, including checks, shall produce the effect of payment only when they have been cashed. Under the article of 1233, A debt shall not be understood to have been paid unless a thing or service in which the obligation consists have been completely delivered or rendered, as the case may be. For example, X promised to pay Y 5,000. Also, X bound himself to repair the bicycle of Z. If X paid his obligation of 5,000 to Y, there is a payment. However, if there is advance payment of 3,000, leaving the remaining balance of 2,000, then there is no payment. Likewise, if X repaired the bicycle of Z, there is performance. But if X partially repaired only the bicycle, then there is no performance. Article 1234. If the obligation have been substantially performed in good faith, the obligation may recover as if there have been a strict and complete fulfillment, less damages suffered by the obligee. Under the article of 1235, when the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. General is the principle of integrity. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Also, there is an exemption. If the obligation has been substantially performed in good faith, the obligor may recover as though there have been a strict and complete fulfillment, less damages suffered from the obligee. For example, sa ilang kontrata, X obliged himself to manufacture and deliver 10 chairs for Y at 1,000 per chair. However, due to lack of lumber because of the recent super typhoon, X only manufactured 8 chairs and delivered it to Y. In this case, X presumed to be in good faith, hence he can recover 8,000, which is the 1,000 times 8 chairs.
Substantial performance doctrine. The rule that if a good faith attempts to perform does not precisely meet the terms of an agreement or statutory requirements, the performance will still be considered complete if the essential purpose is accomplished, subject to claim for damages for the shortfall. So, Article 1235 states that when the obligee accepts the performance knowing its incompleteness or irregularity and without expressing any protest or objection, the obligation is deemed fully complied with. So example, in their contract of sale, X obliged himself to deliver 10 tablets to Y at 1,000 per table. Thereafter, X delivered 9 tablets and was accepted by Y with the knowledge that it is incomplete. Y paid 9,000. So therefore, the obligation of X is extinguished. So note that if the buyer failed to pay the down payment on time, but then the seller accepted without any objection the delayed payment of the buyer, hence the Supreme Court held that as provided in Article 1235 of the new Civil Code, the obligation of the buyer is deemed complied with. So the word accept, as used in Article 1235 of the Civil Code, means to take as satisfactory or sufficient or agree to an incomplete or irregular performance. So now let's proceed to Article 1236. So Article 1236 states that the creditor is not bound to accept payment or performance by the third person who has no interest in the fulfillment of the obligation unless there is a stipulation to the contrary. So the question is, to whom can the creditor must accept payments? So the creditor is bound to accept payments or performance from the debtor, any person who has interest in obligation, like guarantor, and from a third person who has no interest in obligation when stipulation that he can make payments. Let's proceed to paragraph 2. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. So what is the effect of the payment by a third person? So if the third person paid without the knowledge or against the debtor, the payer can recover from the debtor only insofar as the payment has been beneficial to the latter. In other words, the recovery of the payment is only up to the extent or amount of the debt and in the time of the payment. And if the third person had a consent or paid with the knowledge of the debtor, the payer shall have the rights of the reimbursement or subrogation, that is, to recover what he paid, not necessarily the amount of the debt, and to acquire all the rights of the creditor. When we say subrogation, the, the payer steps into the shoes of the debt of the creditor, meaning that person has now entitled to exercise all the rights and action of the creditor. Example, X owed Y 10,000. Z, a neighbor, wants to pay the obligation of X. In this case, Y is not bound to accept the payment of Z because he has no interest in the fulfillment of the obligation. Z is not a guarantor nor a pledger. Not the less, if Y accepted the payment of Z, the latter can recover from X with interest. But if the payment of Z is without the knowledge of X or against his will, then Z can recover only the 10,000 based on the principles of unjust enrichments or the case of solutio in debite. Now let's proceed to Article 1237. Article 1237 states that whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. As what I have said earlier, if the third person paid without the knowledge or against the will of the debtor, he cannot compel to, or he has no right to compel the creditor to subrogate its rights. For example, X is the debtor of Y in the amount of 100,000. This is secured by a real estate mortgage over X parcel of land. If Z, a third person, paid the obligation of X without the debtor's knowledge or against his will, then Z cannot foreclose the mortgage in case of default or the obligation by X. Now let's go to Article 1238. Article 1238 states that payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires the debtor's consent, but the payment is in any case valid as to the creditor who has accepted it. So if the third person does not seek reimbursement or don't want to be paid back, that payment is considered by law as a donation. Without the consent of the debtor, there will be no contract of donation. Whether or not the debtor accept the donation, insofar as the creditor is concerned, the payment is valid. Example, a classmate of X paid a latter obligation to Y in the amount of 3,000. Z intend that the payment will be his gift to X by the virtue of the latter's birthday 2 days ago. X consisted to this donation. So in this case, the obligation of X is extinguished. So Article 1239 states that an obligation to give payment made by one who does not have the predisposal of the thing due and the capacity to alienate, it shall not be valid without prejudice to the provision of Article 1427 under the title on natural obligations. So, predisposal of the thing due means that the thing to be delivered must not be subject to any claims of a third person. Capacity to alienate means that the third person is not incapacitated to enter into contracts. So general rule in Article 1239, so payment by incapacitated person is not valid. So example, X S agreed to sell to B a television set. If the television set delivered to B by S belonged to C, the same can be recovered by C because the payment is not valid. So Ace does not have predisposal of the television set. The same right of recovery exists although the television set belonged to S. So kung kang S pod if he is a minor and therefore has no capacity to alienate it. So na-exemption ang Article Article 1239. So according to Article 1427 of the new Civil Code provides When a minor excess was entered into a contract without the consent of the parents or guardian, voluntarily pays a sum of money or delivered a fungible things in fulfillment of the obligation, there shall be no right to recover the same from the obligee who has spent or consumed it in good faith. So now let's proceed to Article 1240. Article 1240 states that payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. So to whom payment must be made? So the payment must be made first by the person in whose favor the obligation has been constituted, or the creditor or obligee, his successor in interest, or any person authorized to receive it. So in whose favor the obligation has been constituted. So it referred to the creditor the time of the payment. Not necessarily necessarily the creditor is the constitution of the obligation. Hence, if a person is subrogated to the right of the creditor, payment should be made to the new owner. So the person to whom the payment must be made by either authorized by law or authorized by the creditor. In other case, when payment is made by the by the debtor to the wrong party, the obligation does not extinguish or not valid. Example: D owns C 1,000 at 10,000. In this case, D must pay C or any person authorized by C, or in case of his death, his heirs, or any person authorized by law. Payment to any other person is not valid except as provided in paragraph 2, article 1241. That D acted in good faith in paying the wrong party is not an excuse.
Hi everyone, I am Denise Nicolai Biocohido and I'm going to talk about the effects of payment to an incapacitated person and the definition of dasyon in Pugo. So I'm going to talk about first the effects of payment to an incapacitated person. So when we say incapacitated person, these are the individuals who are unstable to make rational decisions or care of themselves due to mental or physical impairment. So kanang na ay mga mental illness or mga physical conditions. So if the payment was made to an incapacitated person, the general rule is that it is not valid. However, there are exceptions. So first, if the payment benefited the incapacitated person. So for example, kung ang payment kay gipalit sa food or shelter of the incapacitated person or iya gibayad sa medical expenses, so ang payment sa debtor is valid. So for example, nagbayad ang debtor og 20,000 pesos sa incapacitated person and the person na out of his mind, iyang gilabog ang 15,000 pesos sa river. So ang 5,000, maura to ang valid nga payment sa debtor. So next exception is if the payment is made to a legal guardian or the authorized representative. So kung ang debtor kanang nagbayad sa payment ato sa legal na kanang guardian or authorized representative sa usa ka incapacitated person, so the payment will be recognized as valid. And lastly, if the incapacitated person later ratifies the payment, so kung mubalik na ang capacity sa incapacitated person and iya gi-confirm ang payment sa debtor, so ang payment sa debtor is mahimo na siyang valid. So when we say dasyon in Pogo, it is a legal concept which a debtor transfers ownership of property to a creditor as a substitute payment of a debt. So sa debtor, instead mubayad siya og cash, he will settle his obligation through giving an asset such as land, house, or a property pero dapat with the consent of the creditor. So for example, the borrower cannot pay her loan anymore so iyang gihatag ang iyang buy sa bank. If the bank accept it, her loan will be considered paid through dasyon in Pugo.
Of the Civil Code, the creditor cannot be compelled to accept partial payments from the debtor unless there is an express stipulation to that effect. More so, H&W cannot substitute or apply as their payment the value of the chicks and byproducts they accept to derive because it is necessary that all the debts B for the same kind, generally of a monetary character. Needless to say, there was no valid application of payment in this case. Article 1249, the payment of debts in money shall be made in the currency stipulated, and if it is not possible to deliver such currency, then in the currency which is legal tender in the Philippines. The delivery of promissory notes payable to other or bills of exchange or other mercantile documents shall produce the effect of payment only when they have been cashed, or when through the fault of the creditor they have been impaired. In the meantime, the action derived from the original obligation shall be held in the abeyance. Rules in payment of debts in money. Number 1. The payment of debts in money shall be made in the currency stipulated, and if it is not possible to deliver such currency, then in the currency which is legal tender in the Philippines. Number 2. The delivery of promissory notes payable to order or bills of exchange or other mercantile documents shall not produce the effect of payment except A. when they have been cashed, B. when through the fault of the creditor they have been impaired. What is legal tender? The money, bills and coins approved in the country for the payment of debts, the purchase of goods and the exchanges of value. Through jurisprudence holds that, in general, a check does not constitute legal tender and that a creditor may validly refuse it. It must be emphasized, however, that this dictum does not prevent a creditor from accepting a check as payment. In other words, the creditor has the option and the discretion of refusing or accepting it. While it is true that in general a manager's check is not legal tender, the creditor has the option of refusing or accepting it. Payment in check by the debtor may be acceptable as valid if no prompt objection to said payment is made. Problem. On October 20, 1988, Y and spouses H and W entered into a contract to sell involving a parcel of land. At that time, the land was untitled, although H and W were paying taxes thereon. Under the contract, Y undertook to secure title to the property in H and W's names. Of the 312,840 pesos purchase price, Y was to pay a down payment of 50,000 pesos upon signing of the contract, and the balance was to be paid within 10 days from the issuance of a court order directing issuance of a decree of registration for the property. On December 27, 1989, the court ordered the issuance of a decree of land registration for the subject property. H and W then demanded payment of the balance of the purchase price. On February 28, 1990, Y made a payment of 100,000 to H and W, still insufficient to cover the full purchase price. In a letter dated April 17, 1990, H and W offered to sell to Y one half of the property for all the payments that latter had made. Instead of rescinding the contract, if Y did not agree with the proposal, H and W said they would take steps to enforce the automatic rescission of the contract.
Good day, everyone. I am Arcade A. Montabate, and I am going to report the Article 1250 and Article 1251. So let's talk about Article 1250 first. So Article 1250, in case an extraordinary inflation or deflation of the currency stipulated should be supervened. The value of the currency at the time of the establishment of the obligation shall be the basis of payment, unless there is an agreement to the contrary. So let's define the term first. So the first term is the inflation. If it is an inflation, it is a sharp sudden increase of money or credit, or both without corresponding increase in business transaction. So it means it causes a drop in the value of money, so it resulting money in the rise of the general price level. So if it is an deflation, it is no reduction in volume and circulation of the available money or credit. Deflation is the opposite of inflation. So there are two requisites for supervisions. So first, there is an official declaration of extraordinary inflation or deflation from the Bangko Sentral ng Pilipinas. So second is the obligation is contractual in nature. So if it has a stipulation, it talks about contracts. So Article 1250 is applicable only to case where a contract or agreement is involved. So more importantly, the parties must agree to recognize the effect of extraordinary inflation or deflation. So at present, the inflation in the Philippines is only ordinary and not extraordinary. So if it becomes extraordinary, the basic of the payment is the value of the currency at the time obligation is constituted. So next is the Article 1251. So Article 1251 tells about the place where the obligation shall be paid. So first rule, if there is no stipulation at the place designated or if asa gistoryahan nga adto mo bayad, if there is no stipulation, then we have to classify if it is a delivery or specific or determined thing. So, but if a specific thing, sadly payment shall be made at the place where the thing was at the time of the perfection. So, kung asa nakabutang specific thing at the time sa katong perfection. So, second, if the delivery of the obligation is consists of the delivery of indeterminate or generic thing, ingon ang delivery or payment must be made at the domicile or debtor, and if the debtor changed the domicile in bad faith or after nag-incur ng legal delay or default katong additional expenses, ang debtor maoy mubayad. So, filing of case kung asang venue, it is actually the place where a court or action or a court suit must be filed or instituted. So that's all of my part. So thank you.
Good day everyone, I am Kimberly Ann Sonora and I am here to report about the application of payments, subsection 1 of chapter 4, extinguishment of obligation. Article 1252. He who has various debts of the same kind in favor of one and the same creditor may declare at the time of making the payment to which of them the same must be applied, unless the parties so stipulate or when the application of payment is made by the party for whose benefit the term has been constituted. Application shall not be made as to debts which are not yet due. If the debtor accepts from the creditor a receipt in which an application of the payment is made, the former cannot complain of the same unless there is a cause for invalidating the contract. So, what is application of payment? Application of payment may be defined as a designation of the debt to which the payment must be applied when the debtor has several obligations of the same kind in favor of the same creditor. So, take note, application of payment involves several debts, meaning daghang utang and only one creditor and debtor same ra. For example, X owes Y different amount with various due dates. If X makes a payment, they can choose which debt to settle first. If they don't specify, Y can decide. Then, requisites of application of payment. 1. There must be only one debtor and only one creditor. 2. There must be 2 or more debts of the same kind. So, dapat di ka usang imong utang. Dapat 2 or more debts of the same kind. 3. All of the debts must be due. 4. The amount paid by the debtor must not be sufficient to cover the total amount of all the debts. So, ang amount nga i-pay sa debtor dapat dili mulapas sa amount sa ilang utang. So, it is important to know the rules of application of payment para maibuan kung asa na utang ang na-extinguish. So, the rules on application of payments. First, the right to designate the debt to which the payment shall be applied belongs primarily to the debtor. He may declare at the time of making the payment to which of them the same must be applied. So, ang debtor naa sa right nga mo decide kung asa nga utang ang inyong pairan. Then 2, if the debtor does not apply payment, the creditor may designate which debt is paid by specifying in the receipt. So, kung ang debtor din niya ma-specify kung asa niya i-apply ang inyong payment sa inyong mga utang, ang creditor ang mo decide ug inyong i-specify dito sa receipt. Then number 3, if the creditor did not apply or if application is void, the debt which is most onerous to the debtor among those due shall be deemed to have been satisfied. So onerous means something that is burdensome or costly. It has more obligation than benefits. So if the debts due are of the same nature and burden, the payment shall be applied to all of them proportionately. So if ang debts is para sa same nature sa o burden po sila, ang payment is split, or sa kada utang sa iyang mga obligation is ang iyang payment na mabayaran dito. Note, where the debtor has not expressly elected any particular obligation to which the payment should be applied, the application by the creditor in order to be valid and lawful depends on 1. Upon his expressing such application in the corresponding receipt, and 2. Upon the debtor's assent shown by his acceptance of the receipt without protest. This is the import paragraph 2 of Article 1252 of the new Civil Code. If the debtor accepts from the creditor a receipt in which an application of the payment is made, the former cannot complain of the same unless there is a cause for invalidating the contract. Ultimately, therefore, the application by a creditor depends upon the debtor acquiescence thereto. Note, debts covered by a guarantee are deemed more onerous to the debtor than the simple obligations. So, ang kanang debts nga na ay guarantee is onerous siya, means burdensome siya sa debtor, creditor, and the guarantor. Because in their case, the debtor may be subjected to action, not only by the creditor but also by the guarantor. So, ang debtor, pwede siya kanang kasuhan sa creditor and the guarantor. Kaya ang kanang guarantor, other person siya nga ning sign or ning guarantee nga mabayaran sa debtor ang utang. So, liable siya if dili mabayaran sa debtor ang utang. Siya ang mabayan. Then, ang mabayaran na sa guarantor, ang si debtor na utang ng guarantor. And this is even before the guaranteed debt is paid by the guarantor. Hence, the payment of the guaranteed debt liberates the debtor from liability to the creditor as well as to the guarantor. So, if mabayaran na ni debtor ang iyang utang, kanang ma-free na siya sa guarantor o sa creditor. While payment of the unsecured obligation only discharges him from possible action by only one party, the unsecured creditor. So, here is a problem of a guarantee case. Anna owes 2 debts, guaranteed debt and unsecured debt. Nanguwang si Ja og 50,000 from Bank A, and their friend Ben signed as a guarantor, meaning if Anna fails to pay, Ben is responsible. So, ang unsecured debt is nanguwang po si Ja og 30,000 to a lending company without a guarantor. So, if Anna doesn't pay the guaranteed debt, both the bank and Ben can take legal action against her. So, mo itong miingon na pwede makasuhan ang debtor if dili siya mo bayad. So, Article 1252 gives the right to the debtor to choose to which of several obligations to apply a particular payment that he tenders to the creditor, but likewise granted in the same provision is the right of the creditor to apply such payment in the case the debtor fails to direct its application. So this is obvious in Article 1252, Part 2. If the debtor accepts from the creditor a receipt in which an application of payment is made, the former cannot complain of the same. So, a debtor in making a voluntary payment may at the time of payment direct an application of it to whatever account it chooses, unless he has assigned or waived that right. If the debtor does not do so, the right passes to the creditor, who may make such application as he chooses. But if neither party has exercised its option, the court will apply the payment according to the justice and equity of the case, taking into consideration all its circumstances. So, if neither ni debtor o ni creditor di nila ma-exercise ang mga option katong if ang mga option is katong mo choose si debtor of dili si creditor, So, moabot na sa court. Ang court ang mo-apply sa payment and according to justice and equity. I-consider nila ang tanan nga na-involve as tanan nga na-involve all its circumstances. So, Article 1253, if the debt produces interest, payment of the principal shall not be deemed to have been made until the interest have been covered. So, if ang debt nag-produce ng interest, ang payment sa principal is dili siya ma-deem if dili mabayaran ang interest. Kay, if kintahay, mo loan sa bangko and then nasa contract na interest like 12% per annum, dapat bayaran po sa debtor ang interest kay part man sa ilang contract and na right man na sa bank na mabayaran ang interest kay ni-serve sila or na sila gipaloan ang debtor nila. So ang interest is muna siya ang core sa bank's existence. Then, Article 1254, when the payment cannot be applied in accordance with the preceding rules, or if application cannot be inferred from other circumstances, the debt which is most onerous to the debtor among those due shall be deemed to have been satisfied. The debts due are of the same nature and burden. The payment shall be applied to all of them proportionately. So, naadyo yung mga naay times na naay onerous debt. So, if pareha nga onerous tanan or pareha nga burdensome tanan, dito na ma-apply na split ang payment sa kada utang kay burdensome man sila tanan. So, the above, ang Article 1254, the above article explains that in case the debtor does not make the application of payment or the creditor does not also state in which application of payment is made, then application is made by operation of law. That is the debt which is most onerous to the debtor. However, if the debts due are of the same nature and burden, meaning there is no debt which is most onerous, the payment shall be applied to all of them proportionately. Motong ingon nga split na and then naadyoy mapili. For example, M is registered owner of condominium unit of number 403 on November 29, 1991. M as a seller and H as buyer executed a provisional deed of sale, whereby the former sold to the latter the aforesaid condominium unit for the amount of 1 million pesos to be paid upon the execution of the contract and the balance to be paid through Y-Bank post-dated check. So, pinaagi sa Y-Bank na cheque ang mode of payment. Then, subsequently, in a letter dated January 22, 1992, H informed M that his checking account with Y-Bank has been closed. Na-close ang bangko, ang account ni M sa Y-Bank, and the new checking account with the same Drawy Bank is open for practical purposes. The letter further stated that the post-dated checks issued will be replaced with new ones in the same Drawy Bank. So on January 25, 1992, H through W, wife or H, paid 200,000 pesos. Acknowledged by him as partial payment for the condominium unit subject to this controversy. So, yung bayad ang wife ni H, which is si W, o 200,000 pesos as partial payment. Then, on July 26, 1992, M sent H a notice of cancellation of the provisional deed of sale. However, despite the notice of cancellation from M, the latter accepted payment from H. On February 24, 1993, M filed a complaint for unlawful detainer against H, which obligation is more onerous to the debtor. So, ang most onerous diri is ang rental. Oh yes, ang rental. On October 28, 1992, H made a payment of 100,000 that may be applied either to the back rentals or for the purchase of the condominium unit. On February 30, 1993, M gave H a notice to vacate the premises and to pay his back rentals. Failing to do so, H's possession became unlawful and his eviction was preferred. Hence, on February 24, 1993, M filed an action for unlawful detainer against H. Now, H contends that M's subsequent acceptance of such payment effectively withdrew the cancellation of the provisional sale. The court does not agree. Unless the application of the payment is expressly indicated, the payment shall be applied to the obligation most onerous to the debtor. In this case, ang gatong unpaid rentals is more onerous obligation of H to M. As the payment did not fully settle the unpaid rentals, M's cause of action for adjustment survives. Wa man ning agree ang court sa M's subsequent acceptance of such payment effectively withdrew the cancellation of the provisional sale. Wa ning agree ang court sa iyang gi-file na action. So, thank you.
Hello everyone, I am Shane Allen, and as the continuation of our discussion, I was tasked to report subsection 2, payment by session. Article 1255, the debtor may cede or assign his property to his creditors in payment of his debts. This session, unless there is stipulation to the contrary, shall only release the debtor from responsibility for the net proceeds of the thing assigned. The agreements which, on the effect of the cession, are made between the debtor and his creditors shall be governed by special laws. So, the payment by cession discussed. So, subsection 2 discusses payment by cession, which is a legal way for a debtor to settle their debts by assigning or transferring their properties to the creditors. So let's move on to what is payment by cession. Cession or assignment may be defined as a special form of payment whereby the debtor abandons all of his property to the benefits of his creditors in order that from the proceeds thereof the latter may obtain payment of their payments. Mo ni si Jambo kasabot nga ang debtor, which is ang nangutang, ijang i-transfer ang ijang asset, and an example of an asset is a property, ngadto sa ijang gikautangan, which is ang creditors. Ang mga creditors, para madidakan ang ijang obligation or ang ijang utang ngadto sa mga creditors. So, there are requisites of payment by cession. First is, there must be 2 or more creditors. 2 or more means dili usa, kung dili duha or mas daghan pa kaysa sa duha. Article 1255 contemplates the existence of 2 or more creditors and involves the assignment of all the debtor's property. Muna ni siya ang pagbahin-bahin sa property ni debtor ngadto sa mga creditors. Number 2, the debtor must be partially or relatively insolvent. So, ang meaning sa insolvent is dili kaya bayaran ang utang. So, it is like unable to pay the debt owed by the debtor to the creditor. And then, third, there must be an acceptance of the cession by the creditors. So, of course, dapat jud dawat sa creditor ang cession. So, an example for this is X owes 1 million pesos to Y1, 2 million pesos to Y2, 3 million pesos to Y3, and 4 million pesos to Y4, for a total debt of 10 million pesos. The non-cash assets of X have a book value of 7 million pesos, And the concept of payment by cession is that X will deliver his non-cash assets to Y1, Y2, Y3, and Y4, who will sell it and deduct the proceeds to X obligation. Hence, if they were able to sell X assets for a total amount of 6,500,000, the remaining obligation of X to Y1, Y2, Y3, and Y4 will be 3,500,000. So in summary of the example, payment by cession is typically used in cases of bankruptcy and insolvency. It is a way for the debtor to settle as many obligations as possible with the existing assets. So, the effects of payment by cession. This cession, unless there is stipulation to the contrary, shall only release the debtor from responsibility for the net proceeds of the thing assigned.
So now we're gonna differentiate dation in payment and payment by cession. So, in dation in payment or dation in pago, there may be only one creditor, while in payment by cession, it is the opposite. Because in payment by cession, plurality of creditors is essential. Also, in dation in pago, the debtor is not necessarily in a state of financial difficulty. So, this means na ang nangutang si debtor, wa si jay like financial difficulties or wa si jay nagkalisod. So, capable si jay na bayaran ang utang. While in payment by cession, the debtor is in a state of partial or relative insolvency. Mga lagi si jay nga dili si jay capable or dili si jay kaadyo capable nga mabayaran ang utang. In dation in pago, what is delivered by the debtor is merely a thing to be considered as the equivalent of the performance of the obligation. Meaning nga ang thing or ang butang nga gibayad sa creditor is mao siyang equivalent sa utang. So kibali og like mangutang nakoy utang and then ako siyang bayaran og ref. Ang equivalent sa ref is mao to siya ang equivalent pod sa ahong giutang ngadto sa creditor. While in payment by cession, what ceded by the debtor is the universality of all his property. In dation in pago, the payment extinguishes the obligation to the extent of the value of the thing delivered, either as agreed upon or as may be proved, unless the silence of the parties signifies that they consider the delivery of the thing as the equivalent of the performance of the obligation. So, ang meaning in ani is, or ang buot pasabot ingani, dation in payment or dation in pago means nga ang butang naggihatag sa debtor like mo na sadyang equivalent sa bayad sa utang ngadto sa creditors. While in payment by cession, the effect is merely to release the debtor for the net proceeds of the things ceded or assigned, unless there is a contrary intention. So in payment by cession, ang tanang like properties ni debtor is gibahin-bahin siya ngadto sa mga creditors aron mabayaran ang iyang obligation or ang iyang utang ngadto sa mga creditors. So that's it. Bye.